Welcome to today's broadcast of North Idaho College Public Forum. The crew is comprised of NIC television students, and your moderator is North Idaho College political scientist Tony Stewart.
This is the year of the Bicentennial Constitution, or the 200th anniversary of our Constitution of the United States. We've done a couple of programs on that subject, and we're very happy to continue to celebrate the 200th birthday with another program. I'm so happy to welcome to our program three professors from Boise State University and Idaho State University that are in our city in cooperation with the Idaho League of Women Voters and a humanities grant to discuss this important subject. I welcome to the program, first of all, Dr. Pat Bueller, who is a professor of history and education and in the field of constitutional interpretation at Boise State University. We also have Dr. Dave Adler, who is a professor of political science, and his specialty with us today is constitutional law and foreign policy, and he's with Idaho State University. And our third guest is Dr. Hudson Bueller, who is professor of history at Idaho State University, and he likes to discuss early American history. Gentlemen, welcome to the program. It's a special privilege to have you here.
Thank you.
And I'm very happy to have, for the first time on the program in the form of a panelist, Mr. Ken Howard, who is the president of the Idaho Trial Lawyers Association, and he will join State Senator Mary Lou Reed to question our guest. And I shall invite Senator Reed to commence the questioning.
Thank you, Tony. Gentlemen, let's start out with talking about the health of the Constitution today. In particular, the whole question of the three equal and independent branches of government that the Constitution created. And following the Bork nomination hearings, and I think that we're certainly aware of the conflict at this point among the three branches. Would you start out, Dr. Bueller, and what do you think, how healthy is the whole question of equal and independent branches?
I've just spent 20 hours or more watching on C-SPAN the Bork hearings, and I come away from those hearings with a great pride in the process of the judicial nomination, the advice and consent process. I sense the three branches are fine and strong right now, and that I think the Bork hearing, regardless of the outcome, is an indication of that vitality and strength. We've had, over these 20 hours plus, a kind of basic course in constitutional history and law.
A real short course.
I've just marveled. I've just taken great joy in watching this process, regardless of the outcome.
Dr. Adler, what do you think about the balance of power of the three branches?
Well, I think in terms of the area with which I'm most concerned, and that is the way in which the Constitution governs the conduct of foreign policy, I'm very disturbed. I'm very disturbed because nowhere in our constitutional law is there a more profound difference between constitutional principle and exercise of governmental power. The last 50 years has witnessed a steady aggrandizement of power within the office of the presidency, and numerous presidents, especially in the last 35 years, have violated the Constitution frequently and steadily in the area of foreign policy, especially in the area of war making. And I lose sleep over these matters.
Is there a way to extend the Constitution beyond our boundaries in order to apply it to foreign policy?
Certainly the Constitution could always be changed to reflect whatever Americans think the present day needs, demand, or require. But as a matter of fact, I'm not in favor of any constitutional revision. What I'm in favor of is that the President would adhere to the present Constitution, and that both the judiciary and the Congress would force the President to adhere to our constitutional limitations.
I'm sure we'll come back to that whole area. Let's move on to Dr. Hudson Bueller. And how do you think about what do you think right now about
I agree with Pat that we've had quite a civics lesson this summer. And if we go back to the Iran-Contra hearings, it couldn't have come at a better time in terms of celebrating and getting us back to basics. I think that's what we tried to do with this program, this whole program, was to ask ourselves and to ask the general public to think about the Constitution in substantive ways instead of just to give obeisance to the document, that it deserved, in the 200th anniversary of its signing, it deserved a serious discussion of the issues just as it got 200 years ago. And I think Americans are rallying to that appeal across the nation, and in Idaho as well.
Do you think they're looking forward as well as backward? Is this more of a historical review, or do you think it really is being applied to 200 years from now?
I think it really is being applied to the future as well. And certainly we're asking ourselves and our audiences to make applications to the future. The future is not some place, of course, that we're all going to one day. The future is coming out of today and what we do today, and also what we've done in the past. So certainly we're challenging ourselves to look ahead and to make this document and to see if the document will lead us ahead. I think most people think that it will.
Thank you.
Ken Howard.
I guess I'd like to maybe start the same way and see if we can't go through with Dr. Bueller first and ask a single question and ask you to respond to it. Dr. Bueller, part of the issue that's come up in the Bork hearings, and we've heard it in some other contexts in the news releases and stuff recently, deals with this concept of the right of privacy and whether or not there's any right of privacy under our Constitution. The Supreme Court has dealt with the concept of right of privacy in the case called Roe versus Wade, and I'm wondering if from a historical basis or whatever basis you feel comfortable with, you could discuss with us whether or not you think the right of privacy exists under our Constitution.
I personally do. Tonight in our discussion, we're going to descriptively look at the two different approaches to this question, and start, I think, with Griswold versus Connecticut as a kind of that was the question of a state law prohibiting the use of contraceptive sales and also physicians so advising. Well, that set in motion in a lot of ways this whole question of the extending the Bill of Rights, the 9th Amendment, the 14th Amendment, to modern situations, to a world in which wiretapping exists, in which one's home can be heard and, in a sense, observed from hundreds, even thousands of feet away. So that the question of privacy, in the words, I think, of Justice Douglas, a sort of penumbra, the sort of including shadow that the Bill of Rights includes, seems to me in the 1980s to include we must include this notion of privacy. I find myself having some personal agony over Roe v. Wade, but nonetheless the issue of privacy is one I don't find personally. I'm very much in support of that notion.
Dr. Adler, what are your thoughts on the concept of the right of privacy existing under the Constitution?
Well, I would agree with what Pat said in the main. I think that there's no question that at least in certain areas that we have a right to privacy, and there are different constitutional provisions which either speak to it or from which you could certainly and fairly infer a right to privacy. For example, you certainly have the right to the privacy of your thoughts. You have the right to privacy to some degree in your home. You have the freedom of association, which clearly implies that you have a right to decide with whom you'll associate. Those are just three areas in which we certainly have some form of right to privacy. I think the great debate among constitutional commentators today and in the recent past has been as to the scope of this right to privacy, whether, for example, it extends to granting pregnant women an abortion in the first trimester. That, of course, was a very controversial ruling and continues to be controversial. So people engage in debate as to the scope and extent of this right to privacy, but that there is some right to privacy, I think, is clear.
Dr. Hudson Bueller, what are your thoughts on this concept of right to privacy?
Well, my learned colleagues are better able to judge than I these matters on a specific basis. I think on an historical basis, certainly there are within the British Constitution and within American history back into Great Britain this notion of what the state can and can't do in terms of people's privacy. So it's not just, I guess what I would say is it's not just according to Bork, or it's not just according to today that these issues take us back to basics, but then they take us way back in history, back to fundamental charters and fundamental beliefs. And I think it goes back to due process and back to Magna Carta and back to England and things. And it's not just, I guess I'd say, it's not just an American issue, it is an issue of human rights, and wider than just simply the United States and Justice Bork and the United States Constitution as well.
I think I'll start with Dr. Hudson Bueller, because you seem to be last each time we'll reverse this process. There's a very serious debate going on in this country, and I'm very sure that the general public's not followed it because they're dealing with a lot of other problems in life, but experts such as yourself are doing so. And my question addresses the entire Constitution, and I think that debate can then zero in on particular issues such as privacy or foreign policy or whatever. And that is Attorney General Meese's argument that we should go back to the court interpreting the Constitution with the original intent of the Founding Fathers, whatever that was. And there's a lot of debate on what they thought it was. And Justice Brennan's eloquent presentation on the other side that we must have modern interpretation to fit the times. I would like to get all three of you involved in this question. This is a very serious debate, isn't it? And whoever wins that argument, and whichever direction the court goes in, will affect all issues of the Constitution, and that's what you indicated earlier, really the future of this country. Where do you come down on this issue, and how do you think it's going to come out?
I think it's important to say, as you said very well, that it is an important debate. It's also important to say that, again, it is an old debate that goes, and Dave can speak to this better than I, that goes way back in history. So we haven't invented something here as Americans in this bicentennial year. And specifically with regard to your question, I think that there are some areas of the Constitution where original intent can be helpful. There were issues with regard to the functioning of the president, for example, and how people expected that to happen in the Constitutional Convention and in the state ratifying conventions that are of help to us today in judging what the proper role of the president would be in this country. But with other issues, like, for example, abortion, I'm not sure that the issue of original intent is that helpful, because they simply didn't address many of the issues that we find ourselves addressing today. So it is a complex matter, meaning there is a lot of record of this original intent argument, and the Constitution is specific in some areas, but not so specific in others, I would say.
Dr. Adler?
Well, I certainly would agree with what Ron has said. Clearly, as you indicated, how the Constitution is interpreted has tremendous ramifications for the nature of our society. You can just look at a couple of cases, for example, to glean that very quickly. In 1896, the Supreme Court said the Constitution permits racial segregation. In 1954, the Supreme Court interpreted it differently to say that it prohibits racial segregation. Obviously, the nature of society hinged greatly on those two decisions. But as a matter of fact, this argument between Meese and Brennan does go far back. I personally trace it back to the 13th century in England, and it's a very old, very well-heeled doctrine that a judge's responsibility is to attempt to effectuate the intention of a lawmaker, whether it's Parliament, Congress, a constitutional convention, or with respect to a will or administrative statute, any legal document. That's the role of a judge. Consequently, when a judge sits to interpret a statute or a constitutional provision, the judge first looks at language. If the language is ambiguous or further aid is necessary, all judges will first attempt to ascertain what the lawmaker, or in this case, the framers of the Constitution, attempted to do. And certainly in some areas, I would say that original intent can be ascertained. For example, with respect to war making, the framers of the Constitution clearly withheld all authority from the President to initiate hostilities. Only Congress was the repository of any power whatever to initiate hostilities. In other areas, it's problematical. It's not clear that we can ascertain necessarily what the original intent was. But I might just say a word about this debate between Meese and Brennan, and that is that they're not very far apart. Much of what we've seen merely is political rhetoric. For example, on various occasions, Mr. Justice Brennan has invoked the original intent to sustain some of his opinions. So clearly he can't mean that we're unable to ascertain that original intent. Furthermore, the problem with Mr. Meese's adherence or advocacy of this doctrine is that he forgets that we've had 26 amendments to the Constitution, and when he argues that we want to apply the intent of the constitutional framers, he's overlooked the fact that Americans have decided in their judgment on 26 occasions that what the framers talked about or neglected to mention had to be changed.
It's important to tell the viewer, too, that any time an amendment's added to the Constitution, that takes precedence over the original Constitution if it addresses the same subject.
Absolutely. It's just as much a part of the Constitution as any of the original provisions are.
Yes.
Yeah, I want to build on what Dave has said. By any reckoning of who the framers were, those who framed the 13th, 14th, and 15th Amendments, by the logic you just gave, were as much framers as those who framed the first 10. Here's Jefferson, although not a founding father in the sense of being present at the Constitutional Convention. When he opposed Hamilton's plan for the Bank of the United States, was a literalist, a strict constructionist, and said, where does it say in the Constitution that we have a right that there's a right to have a bank? About 7 years later, he was in the driver's seat and somehow found a loose enough construction in the construction of the Constitution to buy Louisiana. So I don't want to sound cynical about this, that one interprets the Constitution in light of one's own political or social needs, but one can't discard that as well. That for a long time, for example, the Supreme Court found in the Constitution the prohibition or the process of prohibiting child labor legislation. I can't conceive of any founding father's notion that would say the Constitution was designed to protect a 13-year-old's right to work in a sweatshop. So the whole notion of original intent has to, in my view, be filtered through economic, political, social necessities of the time. And my own view is the abstraction of principles and the application of those principles into contemporary situations is what the court ought to try to do. I would like to hear a trial lawyer's view on that.
Let's get back to the panel. Just very quickly, one other note, and that is that, as Dave indicated, there are areas that the founding fathers had no idea would exist: nuclear weapons, the space program, airlines, and
Mary Lou might have something to say about the rights of women.
Yes,
precisely.
In the Constitution and in the original intent.
Senator Reed.
It isn't mentioned, is it, Mary Lou?
Well, no, and I'm not going to be drawn into this. We get to quiz you. I want to return to you, Dr. Adler, and your concerns for foreign policy and the Constitution. Would you elaborate on your concerns and also give us some ideas of how perhaps Congress should be asserting itself, or are there ways in which the imperial presidency could be reined in by other forces?
Sure, I'd be happy to. Probably no subject animates me more than this one. To begin with, what the framers attempted to do was to establish a collective decision-making process with respect to the conduct of foreign policy in general, and specifically with respect to war-making. As a matter of fact, it may be surprising to many in the 20th century to note that, in fact, the constitutional text grants most foreign affairs powers to Congress, not the President. In fact, the President's constitutional powers pale by comparison. Congress is granted all powers ranging from the regulation of foreign commerce to the ultimate power of making war. The principal way in which the framers envisioned that foreign policy would be conducted would be by a partnership act, the President and the Senate through the treaty-making vehicle. And in fact, the President is only given two constitutional roles in foreign policy. One is the Commander-in-Chief Clause, but all that meant was that, as Alexander Hamilton explained, was that after the United States is attacked, then he assumes command of the military forces placed under his direction, or else if Congress authorizes war. So the Commander-in-Chief Clause then is very narrowly understood. And the only other clause which confers exclusive authority upon the President in the area of foreign affairs is his duty to receive foreign ambassadors. But that's merely a ceremonial power. As Hamilton explained, somebody has to be there to receive an ambassador. And it's a lot easier to have one person do it than it is to trot out 535 congressmen to shake hands with a visiting ambassador.
Well, what went wrong? I mean, where did it start going out of course?
I think it really began in the 20th century, and especially since World War II. You see, no president prior to Harry Truman asserted a constitutional power to initiate war. He was the first. Every president since Truman has asserted legal authority to make war. And so that means, I mean, we could go into detail about this, but very basically all of the wars since Korea, or all the acts of war, or police engagements, or however you choose to characterize them, have by definition been unconstitutional. Congress has the authority to stop it. It could rein in presidents through
Why
a number of
why have they
devices.
not used it sufficiently? Do you think it's Congress's fault or just aggressive executives?
I think I see sin on both parts. The president has aggrandized or usurped congressional powers. Congress has acquiesced in the face of this theft of power. And I think primarily it's a lack of will on the part of Congress for political reasons.
Would you like to comment? Please do. Yes.
I would agree with Dave that it is primarily since the Second World War, but I would also say that ever since this nation was founded, there has been the belief in the country that it's okay for us to disagree on domestic matters, but when it comes to foreign policy matters, we must unite as one people against our enemy. And we see this from the War of 1812 on. And we see it even in the Congress being used by certain people for partisan attacks, that you absolutely cannot do this because now you're a traitor. And the Civil War, of course, is a classic example.
And so that, to some degree, ties the hands of Congress.
It certainly does.
In relationship to the American people.
It certainly does. And the way to untie it then is for the American people to take foreign policy matters more actively than we have before. We cannot, I think Dave is absolutely correct, we are used to, as a people, let's don't blame the Congress only on this, as a people, we're used to deferring to our president.
So it's really up to the people. What you're saying is to really put the pressure on Congress for whatever direction they think is appropriate. How about, what do you think, Pat?
Well, I'm just thinking of how Dave would react to the War Powers Act. Do you see that as an effort to attempt by Congress to rein in presidential sort of war-making activity illegally? How do you respond to the War Powers Act?
Well, I've written on this, and it's been a source of great concern to me. Very basically, I think as Pat was indicating, Congress attempted to rein in presidential power. It was clearly a reaction to our war in Indochina, and what Congress hoped to accomplish more than anything else was to prevent another Vietnam. That is, to prevent a single individual from taking the nation into war and presenting Congress with a fait accompli. But I've been very, very critical of the War Powers Act because it was ill-conceived and it was flawed in design and structure. It did not nearly succeed in what it attempted to do. As a matter of fact, the great vice of the War Powers Act is primarily that it actually grants to the president more power than the Constitution grants to the president. And I say that because the Constitution gives the president no authority to make war. Congress gave to the president, by virtue of a provision in the War Powers Act, the right to make war for 60 days. Automatically, that means that that provision renders the act unconstitutional in my mind.
And the issue is further complicated by covert activities by the CIA and other agencies that are uncontrollable.
Ken Howard.
We've talked a little bit about original intent, and then we started talking about the powers that the Constitution gave to the President and to the legislature. And one of the things that comes to my mind that I guess I'd like to hear you discuss is that my recollection of the history of the Constitutional Convention was that from the time they convened until the time that they signed the Constitution on September 17th, they spent about a day and a half deciding what powers the judiciary should have, and the rest of the time was spent really being concerned about what kind of powers and how we select presidents, whether we do it directly from the people or whether we have some sort of a intermediary way of doing it, and how we select our legislators. Do you have any thoughts about why our forefathers were so concerned about the president or the executive branch and the legislative branch, but seemed ready to accept an established function for the courts? And maybe I'll start with you, Ron.
Clearly, I think they were reacting to recent history. They were reacting to the government under the Articles of Confederation, where there was no executive authority above the states. The states were sovereign. They were intent on giving powers to the Congress, number one. They were interested, secondly, in making sure there was an executive to make sure that the laws be faithfully executed, number two. And as to the courts, I think they discussed this. I mean, they came at it from perhaps a consensus that the courts were important, but not as important as these other things, because, again, they had perhaps blinders on from recent history of the United States.
Is it in your mind a matter of importance that they gave to the judicial system at that time, or is it also maybe a matter of historical perspective, that they accepted the judicial role as one of being a protector against the monolith of the state, all the way back to the time of the Magna Carta.
Sure.
And so that they accepted the role of the courts and felt comfortable with their role, and maybe felt uncomfortable with the other roles.
I think you could say that.
Yeah, I think so. If I just made one point, it would be that the framers understood that the judges would be constrained to attempt to merely apply the law as it stood and not engage in lawmaking. Admittedly, there's a fine line between interpreting the law and making it, but in the framers' minds, I think they had a pretty good understanding going all the way back to the 13th century in England, that the job of a judge is to apply the law, and what that really means is to effectuate the original intention.
Pat, can you add?
I would just add this, that I think they saw their handiwork as a pretty conservative document. And they saw in it, they built into it many of the safeguards that reflected their concerns. An interesting speculative item is, did they intend judicial review? And there's a lively debate for years about, I think now the consensus is they did. And that by creating this agency, sort of empowered with, or implied empowered with judicial review, they were in fact safeguarding this pretty conservative document to start with. So I think that's why they spent so little time with it. They had laid out the framework. The Judiciary Act establishing the court system, I think, was set it in motion, but it reflected their attitudes.
We're just about out of time, and I just don't go off the air without this question. I lose sleep too, as Dave's indicated he has. Mine has been a concern of the new political right in this country, and I think what at times they do is attack the Bill of Rights. They urge government to encroach upon the Bill of Rights and to legislate their agenda of social behavior. Because of lack of time, I think I'll go to Pat on this because of the area of your expertise. Do you take that very serious, or is there enough checks and balances in the system so that we can have a diverse society and continue to use the Bill of Rights?
We can never take that for granted. It is a factor of education. It is a factor of constant political surveillance. But from know-nothings before and after, the I don't say right necessarily, the extremists from either direction must constantly be, in my opinion, not silenced. They must be challenged with education and with light. I don't think we can ever rest on that score.
Thank you so much. I wish we had more time. I know the panel does. I know Ken Howard, Mary Lou Reed would like to continue that. I thank them for their fine questions. You've been most stimulating. You've helped us celebrate the bicentennial. Thank you.
That was the intent. Thank you.
Thank you.
Ladies and gentlemen, I hope you'll be with us again next week at this same time. Until then, please have a good week. I am Tony Stewart.
North Idaho College Public Forum can be seen at the same time each week over this station. This production was videotaped earlier by an NIC student crew for viewing at this more appropriate time.